Perfect. So, in regards to just settlements in general, like there's many things that you want to do to determine whether or not, you're eligible for a settlement claim, you're eligible to collect, and two, if you were impacted, because not everyone's impacted, even though a lot of settlements happen when there's massive data breaches, and it's usually in the hundreds of millions or in the millions where individuals have been impacted. In this particular case, we're just going to go over, some of the resources I've used in the past to one, learn about data breaches, which ones are active, what's not active, and how you can use it to your advantage. And so this website is Consumer Action. I simply go over to the database and I search the class action database, right? And so if I'm on the home page right now, I'm going to be looking for class actions. And class actions are the ones that involve settlements. All right. And so you want to go to the class action database once you search it up. It's fairly easy. It's going to bring you to this page, right? And this page is going to basically break down some of the open claims, pending claims, and closed claims. So let's say we go to the closed claims, you'll see claims that are dating all the way back to 2015, somewhere even before that, right? So we're looking at 2013 here. These are all old settlements. And for anyone that's interested in learning or even interested in seeing the trends, etc., like this is a really good place to learn about that stuff because these are the actual settlements that took place and the ones that were closed. I mean, even early warnings had a settlement, right? Now it looks like, why isn't it not letting me? Got two people jumping in. It says here that alleges early warnings services failed to properly respond to consumer disclosure requests in violation of that Fair Credit Reporting Act. Individuals who requested a copy of the disclosure file between March 2015 and February 2020, and whose file may have been contained a fraud record, but the file disclosure doesn't use the word fraud, may be eligible for cash payment. And so this is like very specific, right? And so this is why it's important, like when you're looking into any sort of settlement, you're reading it all. And that's like with anything else. So I'm actually going to click on the current claims. We've got Evan Flow. I believe this is like a baby product. This is for like car seats, right? Boosters. Yeah, that's what they are. Booster seats. We got Suffolk County, New York, unconstitutional jail conditions. That's crazy, right? $18 million settlement to resolve allegations that detainees and inmates are subject to unconstitutional conditions. These are all active settlements, guys, right? Now remember what settlements are. Settlements are the company wasn't wrong. They don't want to admit they were in the wrong, so they're willing to pay to avoid accountability. Does that make sense? So that's the whole point of the settlements. We've got, settlements I never even heard of, right? Sport Quad. I don't know who that is. Roadrunner Sports, right? But when we go and read things like AT&T, I'm familiar with AT&T. I use AT&T, so I'd be interested in that, right? So I would click on AT&T and I would read the actual claim because that's what this is, right? So AT&T Incorporated customer data security breach litigation. So the docket number. So they're actually in court, United States District Court of Northern District of Texas. All right. Please note that certain deadlines related to the settlement include the claim deadline, opt-out deadline, and objection deadline have been updated based on court's October 3rd, 2025 order. So if you're a person in the United States whose data elements were included in the AT&T one data incident that was announced on March 30th, 2024, and you are account owner, or line or end user whose data elements were involved in the AT&T 2 data incident that were announced in July. So there's two data breaches, one in March and one in July. You may be eligible to receive a settlement class member benefits from the class action settlement. So if any of you guys are AT&T users, I'm an AT&T users, right? User, and this would be interesting, right? So what I want to share with you is, regardless of what happens in any data breach, the agreement that you went into them with, um, they agreed to keep your information private, right? And then when they breach it, they breach the agreement. So you want to go after breach of agreement and violation of, your privacy, right? And that's backed by the Privacy Act of 1974. And so I'm going to show you how to build a letter using this information to simply submit a claim. And your claim could be an initial notice, or you can just go straight to court with it. But I always recommend sending some sort of a notice because it strengthens your argument, right? You're attempting to resolve it in good faith. You're attempting to fix it, and you're attempting to collect on what's owed to you based off of the fact that, they breached the privacy, right? And so that's part of the agreement. And so there's two angles we would take in this case. We would angle it where we are challenging breach of agreement, right? The agreement was based off of a privacy policy, and you signed an agreement with this company in hopes that they would maintain confidentiality of your personal information because you shared that with them, right? And so it's their responsibility to take care of that. So on this date, AT&T announced that AT&T specific fields were contained in the data release in the dark web, which isn't new. It's happening frequently, guys. I want you to, every time you hear of a data breach, just know like somebody's getting paid and it ain't you. And if it ain't you, you need to start questioning why. These data breaches are for them to just gather information on you, because if you don't consent to give it to them, how else can they get it? They're just going to take it, and they're going to pay a price to take it, right? And that's the settlement. And so this information was leaked in the dark web. So following AT&T's announcement of AT&T One data incident, lawsuits were filed against AT&T in state and federal courts across the country. This lawsuit is considered consolidated before the judge in the North District of Texas, June 2024, and captioned an @AT&T Inc. Consumer Data Security Breach Litigation. So there's a docket number. And so you guys have everything you need to reference the details of each of these cases. But ultimately, one thing I like about these is it actually gives you an opportunity to determine whether or not you were impacted. And so we're going to scroll through. So these are the details of the case, right? There were two data breaches. There was one in March, and another one that occurred later on in June. So now we're going to, or July. So now we're going to keep moving on so we can determine what you can claim from each of these settlements. Okay. And so what was actually leaked here is if you were a part of the to AT&T One data breach. So this is going to be important because these are details of what was truly leaked. So all living persons in the United States whose data elements, which include some combination of names, addresses, telephone numbers, email addresses, date of birth, account passcodes, billing accounts, social security numbers were included in the AT&T One data incident announced on this date. And so these are all things you want to obviously keep in mind when you're building your letter, right? Because these are facts from the case. These are facts from what really happened. And so you're reiterating what happened. You say, "Hey, my data was leaked, which included some of the combination of names of blah, 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 this and that. And now you're listing out all the specifics. This isn't guesswork. It's in here in the settlement. AT&T 2 settlement class, right? Account owners or line end users whose AT&T 2 data elements were involved in an AT&T 2 data incident. AT&T 2 data elements means phone numbers, current, former AT&T customers, including but not limited to account owners, line users, may have been accessible in the AT&T 2 data incident, along with the telephone numbers in which those customers interacted. And this is bigger than anything, guys. Think about that. Even it says here current and former AT&T customers. That's nuts. That means you could be using a completely different service and your info still got leaked. And so technically, if you were the one that was in fact impacted, you can submit a claim. It says it right here, right? Telephone numbers of current and former AT&T customers, including but not limited to. And so these are things that I'm encouraging you guys to read because it's in front of our face. We just have to take the time to go and read this stuff and take action on it, right? And so today I'm just going to show you how to simply create a letter. Don't need to overthink it. We're using everything that's in front of us. Like, I'm not recreating anything here. You understand? So that's why I wanted to show you guys this, because all we have to do is determine the actual true cause of the settlement. Like, why did the settlement happen? Like, what led to it? And whatever led to it is what you're going to use in order to make a claim. And so here it shows as follows, right? There's document loss cash payment and tier 1 and tier 2 cash payment as follows. So document loss cash payment. Each AT&T 1 class settlement member may submit a claim for documented loss cash of up to $5,000 for losses that occurred in 2019 or later. Upon presentation of the documentation that the losses are fairly traceable and AT&T Data 1 traceable to the AT&T Data 1 or AT&T 1 data incident, or a tier cash payment. It's an alternative to the documented loss cash payment. Each AT&T 1 settlement class member may submit a claim for a tier cash payment. A tier cash payment is pro rata share of the AT&T 1 net settlement found fund cash. The funds left after the settlement, administration costs, attorney fees, and services awarded. There are two types of cash payments, right? Tier 1 cash payment and tier 2. And your eligibility for one or the other is based on whether you are a tier 1 settlement class member or a tier 2 class member. AT&T 1 settlement class member has had their social security number included in the AT&T 1 incident, also known as tier 1 settlement class member, is eligible to make a claim for a tier 1 cash payment. Tier 1 cash payment shall be 5 times the amount of the tier 2 cash payment. Damn. So that means technically if tier 1 is up to 5,000, and so tier 2 is potentially 1,000. But we're going to read this one to see, because this tier 1 and tier 2 of the cash payments, the amount of money that will be available for the settlement class member cash payment is unknown at this time and will be based upon the total value of the valid claims received, the settlement administration costs, and the amount of court awarded attorney fees, costs, and service awards. All right, it's based on the total amount based off of the total valid claims received, guys. So, what does it mean, claims received? That means they have to receive something, right? And so, if they just send you a check in the mail with a small amount, who's receiving what? You're receiving a settlement offer, which will then waive your right to actually submit a valid claim. And so as soon as you sign that check or you accept that check or you cash it in, you've contracted with them. You waived all your rights to seek any future settlements, right? Based on any claims or whatever that may be. The AT&T 2 settlement class, all AT&T 2 settlement class members are eligible for documented loss cash payment, and settlement class members may alternatively choose the Tier 3 cash payment. And so this cash payment, each AT&T settlement class member may submit a claim for a document loss cash payment of up to $2,500. And AT&T 2 class members for losses that occurred on or after April 14th, 2024. Upon presentation of the documentation that the losses are fairly traceable to AT&T 2 data incident, account owners may submit claims for themselves and on behalf of their end of line users. So if you have anyone that's on your lines, you can also submit claims for them as well. Remember, they're telling you who can submit claims. They're not going to come and offer this up to you guys. They're absolutely not going to offer this up to you. If you don't submit the claim, you're not collecting. And it doesn't hurt because no one has anything to lose here, guys. You got to trust me on this. You have nothing to lose here because what's going to end up happening is they end up either pocketing that settlement money or you just don't get paid out after they just stole your data. I mean, technically, we lost it all, right? They took our data for nothing, right? We got nothing in return. And so this is the whole point of the settlements. But if you understand how to leverage the entire situation to your advantage, you'll be able to create a letter that will be able to send to them as a valid claim, and which they have to now follow through with. And so the deadline for this, guys, is December 18th, right? So submit a claim form. The only way to receive receive a settlement class member benefit from the settlement is to submit or postmarked on or before December 18, 2025. All right? Exclude yourself by opting out of the class. Right? So receive no settlement class benefit from the settlement. This is the only option that allows you to keep your right to bring any other lawsuit against them. And so this is the option you want to take. This one is actually November 2017 or November 17, 2025, right? Object to the settlement and or attend the final approval hearing. All right, that has to be done on this deadline. Do nothing. You will not receive any settlement, class member benefits from this action, from this class action, and if the settlement becomes final, you will give up your rights to sue defendants. All right, and this is what I was telling you guys before. You basically give up your rights. So this website is authorized by the court, supervised by counsel and parties, and controlled by the settlement administrator approved by the court. This is the only authorized website for this case. And so to call and mail, this is their address for the AT&T incident settlement. So some of you are probably wondering, okay, well, How do I know I was impacted? Well, if you were a user of AT&T data breach, or if you're a user of AT&T in general, right? And the fact that your information was leaked, you can claim, you can make a claim based on the fact that your privacy and your right to privacy was not fulfilled, right? Because your information has now been leaked by a company that you trusted to maintain privacy. You went into agreement with them in agreement that they will maintain your privacy. And so we're gonna take this information here. That's why I'm plugging it into my best friend ChatGPT. Just gonna take it up to here. Can you guys still see my screen?
Yeah.
Perfect. And so I simply just typed in the ChatGPT earlier. I was like, break down, the 1974 Privacy Act, how you can use it to your advantage to pursue a settlement with companies involved in data breach, right? And so it broke it down, and so far this is what it explained, right? And so the Privacy Act of 1974, federal law, governs how federal agencies collect, use, and maintain and share your personal info. Important. So it applies to federal agencies only, right? Not private companies like Equifax, TransUnion, banks, retailers. But if your data breach involves a federal agency or a company, or the company reports to the federal agency, right? The FTC, CFPB, and other standards of Privacy Act give you the strength and leverage in showing negligence, improper disclosure, and failure to protect personal identifiable information. So the core rights under the Privacy Act, right? Be informed about what information an agency collects. So if an agency collects and stores or shares your personal information, they must tell you what they collect, why, how they've been using it, and whether the disclosure is mandatory. So, perfect example I can give you guys is like nowadays, like for me, I've created so many websites in my lifetime. Like you have to have a privacy policy and a terms and conditions page on your website because it's core under privacy rights, right? You could actually be sued if you have a website and you don't disclose that, okay? And so this is something that every company needs to abide by is the personal information. Access your own records so you can demand any records a federal agency has about you, request amendments. If any information that they have on you is wrong, mishandled, you can request corrections and dispute it. Restrict disclosure. So any agency cannot disclose your information without consent unless exceptions apply. You can sue for violations. All right. You can seek damages, attorney fees, and costs. Failure to maintain accurate records, wrongful disclosure, failure to follow Privacy Act procedures. Right. So how can this help you in a data breach claim? So how do you use the Privacy Act in your advantage in a settlement negotiation? So leverage the duty to protect personal information standard, right? The Privacy Act forces federal agencies to maintain uh, records with accuracy, integrity, and confidentiality. You can argue the company failed to meet this standard of care, and you can use the following language. Under the federal standards, including the Privacy Act of 1974, all custodians of personal identifying information are expected to safeguard data with integrity and confidentiality. Your failure to protect this information, my information, constitutes negligence and result damage. And so you're basically leveraging the fact that they simply just have a due diligence to maintain privacy, right? We're not going after something specific like, oh, my phone number was stolen, and because of that, I keep getting spam calls. Now that's too specific, right? Now you have to prove how you're getting spam calls, who's call, right? It's just like how we fight the bureaus. You want to keep it broad, you want to keep it simple, and you want to use what you have to your advantage, right? And so far, we know that their number one job is to maintain privacy. That's it. And they failed to do it. And so now we're holding that against them. Now, on top of that, based off of what the claim states and the facts that are in the court case, it states that we can claim up to 5,000 if you are a AT&T one settlement tier, right? And if you're AT&T two, you can claim up to 2,500. And so now you know how much you can claim based off of what happened, okay? And so we're going to use the act language to strengthen the administrative record. So the unauthorized disclosure of personal information violates established federal privacy principles reflected in the Privacy Act of 1974, requiring custodians of personal data to prevent unauthorized access or dissemination. Okay. Now you're going to use this to demand method verification and security protocols, right? Logs showing what was accessed, investigative steps, how records were stored, what security measures are in place, when to learn of the breach, right? You could leverage all of these in the letter to framework, and then you can type it up as in settlement format where you're asking to settle for X amount of dollars for very specific reasons, right? Emotional distress, loss of time, whatever that may be, we're going to craft the claim. And I'm going to just give you an example if I was to have been submitting one for AT&T. And T. And so I'm going to tell ChatGPT I'm going to use the following AT&T data breach to craft a claim based on like the letter to be crafted as a letter of demand. And now, depending on what state you're in, guys, you can pursue it in small claims. Um, that'll be the quickest way for you to get a resolution because when you start sending letters and stuff, and it's not actually, the court isn't involved with it, they're not gonna take it serious. You gotta be ready to go all the way with them. All right. So in the demand letter, inform party that you plan to pursue small claims. They fail. All right. So let me add the info. So I included the info of the actual data breach that happened, right? Now it's crafting me the letter. So we got this letter here. Let me know if you guys can still see my screen.
Yes, I can see.
Perfect, perfect. So I'm now moving this letter I'm going to craft it so that it's ready to go out as a pre-demand letter. And so it's simple, it's to the point. Notice how I didn't do a lot of work. I understood the basics of the claim. Now we have to craft it in a way where we can actually move forward with submitting it. Okay. And so in this particular situation, that's too big. I need to go smaller. Perfect. All right. You guys tell me if you have a hard time reading that. And so I'm writing this as a formal demand regarding AT&T's failure to safeguard personal identifiable information, both AT&T one data breach incident publicly announced on this date, and so forth, as affirmed the settlement class member, my data elements, including but not limited to name. You notice how it crafted the letter, including everything, guys? ChatGPT also obviously knows what to do, but it's pretty obvious what you should include in the letter, right? You have to include as much detail as possible. It's just like being a witness in a situation where, you're being asked what happened. Give as much detail as possible. And those details that we're sharing in this are facts, right? We didn't create any of this. This is all facts from the data breach. And so this won't be anything new to them, right? It's not like I'm whipping up some UCC law somewhere out of nowhere and trying to enforce it. Right? I'm keeping it simple, short. I'm saying, hey, you have one job, keep my stuff private, and you didn't do that. So now you got to pay. Basis of liability. The Privacy Act of 1974 federal standards. So while the Privacy Act of 1974 applies directly to federal agents, it establishes the recognized national standard of care, of custodianship, accuracy, integrity, and confidentiality of personal data. Federal law requires any collector or custodian of personal information, especially entities providing regulated telecommunication services, to prevent unauthorized access, disclosure, dissemination of personal record, maintain strict administrative, technical, and physical safeguards, ensure the integrity and confidentiality of all personal data in their possession, and promptly address and remediate any data breach affecting the customer's personal information or personal data. Now, AT&T failed to meet these established federal privacy protections related to wrongful disclosure of personal information subsequent to the risk of identity theft, financial losses, significant emotional distress. These failures demonstrate the data breach of AT&T's duty to reasonably protect my private information. And so notice how all these are just being built off of the information on the case. And so now it's stating the background of the incident, right? It's articulating everything that happened, right? Both incidents were later consolidated and resolved via global class settlement without any admission of wrongdoing. And so remember what I told you. I told you that it all comes down to them failing to admit. They don't want any accountability, zero accountability. They'd much rather break the rule and the law and pay. That's why when you ever think about the law, guys, there is no law, right? The law is meant to be broken at a price. And that's what these companies are doing. It's meant to be broken at a price. You ever think about speeding ticket? What's most people's biggest fear with speeding tickets? They don't want to pay the price. They just don't want to pay the price. And so if they could keep speeding, they would keep speeding. Or if they're willing to pay the price, they'll keep speeding. Right? But not a lot of people are willing to do something like that. And so, but at the end of the day, it's there to be broken. Now, I'm not encouraging you guys to go out and speed and, any of that stuff by all means. I'm just saying that's just the reality of it because it's in front of our face, right? They're consistently leaking information, guys. I mean, Just do your research on how many data breaches happened in the last decade. It's unbelievable. They only have one job is to protect your info. They can't even do that. It's like hiring a lawyer and then your lawyer exposes everything you had meeting with, right? Everything that you disclosed, confidentially. Like it doesn't make any sense. You might as well have kept it to yourself. Might as well have gone into agreement with them. Why do business with them? This class settlement deadline were modified on October 3rd, 2025. I'm aware of the of and acknowledge the updated court order deadlines for the claim deadline, opt-out deadline, objection deadline. So this notice is separate from and not precluded by. And so you have to be specific about that because they will assume that you want to be part of the actual claim, guys. And when you don't opt out and submit your own claim, they automatically think that you're involved. And two, if you don't respond in any way, you will never be part of it and you opt out of all your rights to submit any claims. All right. So I retain my rights to pursue individual relief where losses exceed or differ from the relief available through the settlement. And so all of it is based off the damages that you want to claim. Now, if you want to go small claims, you can go close to, the maximum that you prefer to go to, but you have to be willing to be prepared to prove your case, right? If you suffered emotional distress, you got to be able to prove how, okay? Because the more evidence you're capable of presenting, the stronger your case, and they can't quite argue with that. There's no actual measure to emotional distress, guys. You just have to be able to at least show on record that you suffered from it, right? In some way, shape, or form. And now, for individuals like yourself, let's say, for example, you recently submitted an FTC affidavit, that also can be used as proof. So if you submitted some sort of FTC affidavit for fraudulent accounts or for inaccurate accounts, you can use that because all of those are related to privacy. Okay? All those are related to privacy. And so those are also acceptable forms of evidence. You just need to be able to prove. Remember, it's all about what you can show on paper. It's all about what you can show on paper. Harm suffered as a direct result, AT&T's failure to protect my personal information. I've experienced increased risk, fear of identity theft, right? Time spent monitoring, securing, repairing potential exposure. That can all be related to your credit. Emotional distress resulting from permanent exposure. Now, you guys can use data breaches for any credit repair situation. You could use it for any credit related situation. Because all your credit is your personal information. Costs associated with credit monitoring. So you guys can actually, if you've been using credit monitoring for the last year, you can get reimbursed for that. Like you can submit all of your payments that you made and get reimbursed, right? And then you can also request additional payments for future credit monitoring services, right? Like for example, if it's $24 a month and you want 5 years of credit monitoring just so you can continue to maintain and monitor your credit, yeah, add that up, right? $24 times however many months that is, right? And so then you can make that as part of your claim. And I'll show you how you can do that as we keep going. So these constitute actual damages recognized under the federal privacy principles. Demand for settlement. So to resolve this matter without litigation, I demand a settlement payment of X amount of dollars, right? For AT&T's wrongful disclosure of personal data, negligence in maintaining required security controls, and failure to protect personal identifiable information in federal privacy standards. So this amount reflects emotional distress, time spent mitigating damages, out-of-pocket costs, ongoing risk due to permanent disclosure of personal information, and heightened severity where social security numbers may have been involved. All right, and so you're going to give them 14 calendar days from receipt to actually respond. And if you do not receive a satisfactory response within 14 days, this will proceed with the filing of the small claims action seeking damages, costs, and additional remedies, right? And so we're giving them an opportunity to remedy it before we take it any further. Now, remember where their address is to mail. And so we're going to take it from here. It's not going to AT&T. And so we're going to make sure it's being sent to the proper place. It's where we insert our info. And so you ideally what you want is always you want them to always respond via email. So you always want to put your email here because email is the actual best way. You technically are going to be maintaining um you're going to be maintaining a paper trail throughout the entire process. So you're never having to worry about them giving you a call and then throwing you off course, right? Or convincing you to say something you don't want to say. So email is the best form, and I always recommend to do that with anything. And so it says here, so I mean, we're not going to submit this, but I'm actually giving you guys a real live example of how I would do this. But let's say we had to do it today, I would send this via certified mail today. Like I would mail it certified mail. I would say, hey, I'm opting out. While I have this letter ready to go, it states that you at least have to show that you had submitted it, right? You must mail your request, postmarked on or before. And so if you sent it on today and it arrived, then you technically have met the deadline and you can submit a claim, guys. You can get some money out of this. All right. But if you don't, you kind of lose out. You kind of lose out on that. All right. And so I'm gonna share with you here exactly what happens. So let's say here, remember, it's all based off of the small claims in your particular area, right? So let's say in my state, it's New Hampshire, it's 10,000. I'm saying I'm gonna go for 9,000, right? All right, so I'm gonna go for nine. And how you want to break this all down, guys, is you also, if you have any out-of-pocket expenses, you have to be able to, explain those. Okay. You have to be able to explain those. And so you can say from March, because it happened in March, you can say from March all the way up until now, you can claim credit monitoring. And so, all right, so let's say, for example, we've got credit monitoring, $30 per month. Say Experian, $29 a month. I'm just going based off what I use. I use Experian. I use all of them. Even if I gotta go credit, I still use them. Because the last thing you need to be doing is applying for something and then finding out last minute something changed. And so to me, I don't look as, credit monitoring as an expense because personally, you need it. And most people look at it as an expense. So for March, so April, May, June, July, August, September, October, November, 8 months. It's about $240, right? Say the same thing here. So you're already at $480 just off of this. And all you need to do, guys, is provide them your statements for the invoices you paid. Right? You're gonna claim all that money back. And you also have to think about other things, okay? Think about other things. You can leverage things like the fact that you got denied credit. You can use that to your advantage if you had any inquiries and you had negative information, you submitted any FTC reports, right? If you got denied any credit, right? This is what I would consider an out-of-pocket expense. So let's say out-of-pocket expense is $480. Right? Ongoing risk due to permanent disclosures. So if you want them to, let's say for example, we're paying $60 a month for both. Let's say 3 years. You can request this, right? I'm gonna request 2,160 for the next 3 years of credit monitoring. Time spent. I mean, you can't really put a number on that, right? So put 3,000. But I hope you guys are seeing what I'm doing. I'm just simply building a case, but I'm showing you how I would do it because all of these have to add up too. Hey, Shadi. Not bad, right? 7640. Sound reasonable. So that's what I'm gonna put, all right? And so that's what I'm claiming. But if you want to make this stronger, if you want to leave with some more with money much faster, you can give them an offer where you can also add the damages, right? The potential claims. So I shared that with you guys in the settlement class where I believe I sent a bunch of you guys those letters last night. But in this particular one, I do include here the additional damages. This is also an important one. You never know with the lawyers. It could be 5,000 for a lawyer. I remember I hired a lawyer one time for a small petty case. I paid 5,000, which ended up getting dismissed. I was pissed. Right? So total potential, we're looking at 12,640. And then you want to give them a settlement offer. Which this is the part I love. Say 40%. And so 40% of 12. $1,640. It's not bad. A nice 5K check for doing nothing. And so guys, that's how you convince them to pay you because it's like they're looking at all these costs and they're like, all right, well, they could have claimed even more, but this is what they're asking for. You can go for more, guys. Don't get me wrong. It's entirely up to you. Just remember, if you're gonna go small claims, you want to stay under the actual limit, and you can only submit per claim, right? That max amount per claim. And ideally, when it comes to these settlements, what you want to do is get them to settle with you outside of the court because it would definitely be cheaper for them, right? They have to hire a lawyer. On top of that, they're saving money, and two, they lost anyways. They leaked your info. Like, what are they gonna fight? There's really not much they could fight here. And so now that we have this letter, guys, you would mail it to this address, certified mail, and then see if they have an email on file here for this particular, right? Or you can always call this number to see if they have an email. But like for example, Equifax had an email for a settlement. Let's see if I can find the Equifax data breach here on this website. All right, so you would just simply mail it to that address, certified mail. Why is it in Chinese? Awesome. While we're wrapping this up, does anyone have any questions so far? What are your thoughts on that process? It's pretty straightforward. Has anyone ever thought about doing that?
Yeah, this was a great call, man.
Because this is pretty it's pretty straightforward, guys. I mean, I didn't really recreate the wheel, did I? I read the settlement. I used the Privacy Act. I asked ChatGPT to craft me a settlement offer, right? Like a demand letter. And now we're gonna send it to the address that is in the settlement site.
And you can use that for any.
Yeah, you could use this process for any settlement. You just have to make sure the settlements are active and that you're still within the deadlines. But you will know all of that if you read, if you read the actual settlements, you'll know all of that.
Yeah, I recently got a card in the mail. I said I sign up if you want to go ahead with this class action.
Yeah, don't you want to find out more about it? Usually they have like a website on there or they have some sort of information on it online, and then you want to find out what the deadlines are to submit your own personal claim. You can't be part of the class action. The class action is you opting out. No, is you opting in. When you submit your own personal settlement, you opted out, meaning you can claim for way more, right? So instead of getting the few couple hundred, $300, $7, whatever they want to give you, you can go for a few thousand. You can go for 5,000, 6,000, right? Now you have true damages. Like if you have ways to prove it, guys, you can go to district court, which is obviously going to be a lot more work, but that's where you can claim, a lot of the big tickets. But that takes work and you have to know what you're doing. But what I'm showing you is actually simple and straightforward, and it's one of the quickest ways to actually handle that stuff. People underestimate the power of small claims because remember, what's the worst case scenario? What, AT&T doesn't respond and then you get a judgment against them?
Oh, so in small claims they might not respond, and then a judgment.
Yep. If they don't respond, if they don't show up to court, they issue a judgment against AT&T. And T. And then
Yeah, and these are big companies, so they're definitely gonna pay.
oh,
They
they're definitely
gotta
gonna
pay.
show up. Yeah, they definitely gotta show up. They can't skip that. That's why once you submit it, it's 30-day clock. They can't ignore it, bro. Like there is no ignoring it. They have to respond to the court.
Yeah, if they don't, it's gonna go into default judgment.
Exactly. That's exactly right. And so the whole idea behind this is you're simply forcing their hand and you're using all the data available to you. I didn't overcomplicate it. I just, as long as you know that, they have to actually maintain privacy because you gave them your privacy, your private information, and they exposed it. And so they have to pay. And this is the simplest way I can share with you guys on how to start taking advantage of this stuff. But knowing that at the end of the day, you not responding is you giving up your rights, and then you partake in the class action is also giving up your rights is just as important because no one knows this stuff. I used to go about my day and not realize that, these settlements are literally checks. They're waiting for you to claim the checks. But if we don't actually take advantage and we don't slow down to read what the settlement's about, determine that you were really impacted, how are you going to collect? And so I'm gonna leave it open for a few more questions, guys. Let me know if you guys had any questions regarding what I shared. I know it's a little bit different from what we usually go over, but you guys had brought it up this week, and I figured I'd cover that topic.
I don't have any questions regarding this topic in particular. The only thing that I've been kind of trying to do more research on because I'm in Georgia and I know Georgia has different laws in regards to credit repair.
Yeah.
Um, so I just wasn't sure, like, if I wanted to start, doing this for others, how that would look, in order for me to not get in trouble.
Start your LLC outside of Georgia.
Okay.
Just create a LLC, get a virtual address. I share with you guys how to do that in the campus, in the Business Fundamental campus. I recommend starting one in either Wyoming or Delaware. All you need is a virtual address, and you can operate from anywhere.
Gotcha. Okay. Yep, I'll do that.
You know what I mean? So yeah, absolutely. Georgia is pretty strict with that. But if you're not operating in Georgia as a credit repair business, which I never recommend people do. And I don't know how much access you have so far in the campus, but if you go to the credit repair business automation, I actually share how to start a credit repair business, and how to set it up so you are low risk because I don't consider myself a credit repair business. We're a consulting business because um, it makes it difficult for you to work with processors. It makes it difficult for you to work with a lot of lenders, etc., when it comes to the type of business that you are because it's high risk. And so I always recommend, using consulting or solutions or enterprises and being a coaching and consulting business as a business model.
Okay, yeah, that's what I did. I came up with a name, but I just didn't form the LLC yet. And
Yeah,
it's pretty general. It's the Novera Group. So,
absolutely. That's perfect, right?
hmm.
It's not easy for them to determine what you do. And so now it's like when you get the opportunity, I have multiple LLCs in Wyoming. I recommend it because it's one of the most private states. It does protect all of the members in the business. While Delaware is good with other benefits like taxes and also, business privacy. So I'd recommend that, when you're ready, you could do that. Remember, when it comes to the LLC too, while it does serve as protection, a lot of people think that the LLC is like 911. LLC is important if you start making a lot of money because the more money you make, obviously, the more exposure you have, the more potential it is for people to pursue you for money. And so, ideally, if you're just getting started, it's not always something to rush into until you've got everything pretty much situated. But for someone that's in Georgia, I would set it up in Wyoming and I'll do it as a consulting business.
All right, thank you.
You're welcome.
Can you run past I suppose like the letter of how to with the Privacy Act of 1974 that was like I suppose I have the information from a settlement here in front of me. I have the website as well. Everything that you showed, it looks exactly the same. It has all the information. It's the same PO box and everything.
Mhm.
Um and so yeah.
Yeah, you can create it just like I showed you. I recorded this, so I'll upload this in the campus. Um, you could just rewatch it and just follow, kind of like the process I took because it's pretty straightforward. I needed the info regarding the settlement, and so I used that, and then I have my Privacy Act, and I used both to create a settlement offer, right? So that's ideally all I really did. I didn't really take any other information from anywhere. I simply focused on what the settlement information was sharing.
Okay, but
And nice, Eric. I had looked on I had looked up more research, and that page kind of looks like that AT&T page we was kind of looking at, like the settlement page. It looks
Yep.
exactly kind of like that, and it's easy to break down the way how you was breaking it down. I looked at it, I just said, "Wow, it's just right there."
It's all right there.
Yeah, I'm looking at it like detail for detail, not like crystal clear, like of what you're just saying. You know?
Exactly. It's it's just that, guys, we're in the age of information. Everybody is just so busy, caught up in social media, and then every guru's talking about this and that. We're just missing up on all these opportunities because the info is in front of us.
Nah, I'm gonna take this opportunity because this came from me and my like two sisters. So I'm about to just put this together for me and my two sisters. You know, we're all about to file separate lawsuits,
That's it. And once,
and it says just it don't say opt out. It just says come at them straight.
yeah, yeah. So read the details of the settlement. See if there's any other info online too. Um, and base it off of that. Make sure you send it to their address. If there's any phone numbers you can call, you could always call them and ask questions. Um, but I always follow what's in the settlement. If it tells you send it to an address, that's the address I'm gonna send it to. I'm gonna certify mail it. I'm gonna follow up, and then if they don't respond, then it's going right to small claims.
on a random side note, why can't we can't fax this?
The reason why faxing is like you could fax it. It's just you don't know if their fax bit number is reliable. That's the only thing I would say. I say that because, in the past they used to fax letters to the bureaus and then they started changing them up. And so it was difficult to tell whether or not, they were receiving.
Wild.
And so to avoid that problem, we just simply continue doing what we're doing, right? We send it certified mail because we know for a fact that they're going to receive it and we have a way to verify that it's been received. Awesome. Awesome. Any other questions, guys? Bunch of good questions. I just want to make sure I was able to answer everything and you guys got a lot out of this tonight.
Eric, I'm looking at the more information part, and I see that they got together a whole complaint. I could base my complaint on their complaint.
Yes, yes. As much info as you have on it, the better. It makes it stronger.
Yeah, they have a whole legal complaint that they have that I guess they're filing. It's just not filed yet,
Uh-huh.
but it's all there. I see it all breaking down the whole complaint with all the points broken up.
Exactly. And you can use that to your advantage. I recommend just confirming the deadline first of when you're supposed to submit everything or potentially opt out if necessary.
It say by December 13th.
Yeah, so stick to that
Yeah.
date. Um, Make sure you opt out of the actual class action because the class action, if you don't opt out of the class act, you automatically opt in by a certain date. And so that's what I would do. Submit that claim and you'd be well on your way, man. And they don't really fight these very much, guys, because the money's already there for the settlement. I need you to remember that.
Yeah, they already got like a pot out there for the people to get.
The money's
And I
already
guess
there
if
for the
you come
settlement.
at them, you could get a bigger portion of what you want from that
Exactly.
settlement.
Exactly.
That's
That
at
got
least
me
how I look on it.
that got me wondering, like then how whom is it that puts together these that's like on watch for them?
What do you mean? Like on watch?
So like let's say, okay, th it happened, so who's like to investigate that it occurred? How does
Well,
it
what happens is somebody files a lawsuit. That's what happens. Somebody files a lawsuit and they are going to lose, and so they decide to settle. This is what happens. Whenever they're about to lose a case, they're like, hey, hold on, let's talk. How much do you want? That's their default. I need you guys to realize that. That's what happened. You want to know who's actually tracking this? It's not being tracked. It's that somebody sued them in district court. They were losing and they didn't want that to go public and they didn't want to lose, so decided to pay. That's what
how could
happened.
they prove that the data was actually like obtained, leaked?
That's why you submit your claim. I'm an AT&T member. I'm an AT&T user. I've had AT&T. And T. And so remember, if you read the actual language in there, right? It says that any prior users and current users. So you don't even have to currently have AT&T and you were affected. Does that make sense? It's different for every settlement because when you think about the Equifax settlement, well, how did you determine that you were a victim of the Equifax data breach? You had to put in your last 6 digits of your social and your name, and it pulled it up. It told you you were impacted. And so it depends on the actual company, the settlement. So you have to read through the actual details. But for the one we just covered in AT&T, it said that if you were a prior member or current or even a user on a line, you were impacted. So I always recommend just reading through that class action because it's going to give you everything. Awesome, guys. Any other questions before we wrap up this call? I know this call went a little bit longer than usual, but we covered a lot. Awesome, awesome. All good, everyone. Well, I hope you guys have a wonderful night. Tomorrow, I'll be hosting another call, so hopefully I see you guys there. Other than that, I hope you guys have a wonderful rest of your night and a great day tomorrow.
All right, you too, Eric. Great
Awesome.
call, man.
Thank you.
Absolutely.
Good night.
Have a great night,
All
everyone.
right. Good night, y'all.